To summarize, under the model law, there are two groups of remedies. First remedy, to be filed in the arbitral tribunal that issued the final award, the applications for correction, interpretation, or additional award. And the second group of remedies is the remedy to set aside the arbitral award to be filed in the appropriate court in the seat of jurisdiction.
What I would say about this is that party autonomy is a principle that goes back a long way in arbitration. It is so deeply incorporated into international arbitration as an understanding, as a world, and as a practice that you can see traces of it everywhere, and sometimes you can see it right in your face by way of legislation and rules. And of course, what you then carry on learning within the limits of arbitration or the benefits of arbitration.
The role of the courts is actually very important. In a perfect world, in a perfect arbitration, you don't have to worry about the courts. But unfortunately, the world is not perfect, and all arbitrations are not perfect, and you will need occasionally the support and help of the courts. Usually you rely on the court at the seat of arbitration or the place of arbitration, particularly before and during the arbitration.